Welcome. My name is Elizabeth Snyder, and I serve as one of the co-presidents of the Chicago Forum for Free Inquiry and Expression Student Board. I'm a graduate of the college here at the University of Chicago and a first-year student at the law school. For a bit of background, the University of Chicago Forum for Free Inquiry and Expression was founded in 2023 with a mission to promote the understanding, practice, and advancement of free and open discourse at the University of Chicago and beyond. We are so thrilled to welcome you to tonight's event, The Legacy of Free Speech in America, commemorating the new edition of Defending My Enemy with its author, Aryeh Neier. Lead support for this event comes from the Zell Family Foundation. Defending My Enemy tells the story of one of the most controversial and consequential free speech cases in American history. In 1977, American Nazi Party members wanted to march in Skokie, Illinois, a town with a large population of Holocaust survivors only about 20 miles from where we are today. When the town tried to stop the march, Aryeh Neier, then the ACLU's national executive director and himself a Holocaust survivor, courageously defended the Nazis' First Amendment speech rights, even while denouncing their vile views. Although the ACLU won legal victories in multiple courts, including the U.S. Supreme Court, all over the U.S. and beyond, the case spurred debates about whether the First Amendment and the ACLU should continue to defend the freedom even for the thought that we hate. Neier's powerful 1979 book about the case, Defending My Enemy, remains a classic defense of that core freedom, augmenting the extraordinary educational impact of the case and the national conversation that it inspired. Almost half a century later, at a moment of immense controversy about hateful and extremist speech, the republication of this timeless book by the New Press could not be more relevant. The Skokie case continues to both epitomize America's uniquely speech-protective tradition and stimulate vigorous debates about the boundaries of protected speech. Today's conversations will focus on important lessons from the Skokie case and this landmark book, along with reflections on the state of the First Amendment today. We are joined by Aryeh Neier, author of Defending My Enemy, former National Executive Director of the ACLU and co-founder of Human Rights Watch, along with Nadine Strossen, New York Law School Professor Emerita, former president of the ACLU and senior fellow with FIRE. Please join me in giving our guests a warm welcome. And if any questions come up during the conversation, please submit them to the Chicago Forum mailbox at thechicagoforum@uchicago.edu. Thank you.
Thank you so much for that wonderful introduction and for your great leadership of this wonderful institution. I would like to congratulate and thank Aryeh first and foremost for this wonderful, wonderful book. I read it more often than anything else that I read about the First Amendment, with the possible exception of John Stuart Mill on liberty and Louis Brandeis's famous opinion in the Whitney case. But it's right up there, and I constantly in my speaking recommend the book, but it had been out of print for a long time, and Aryeh generously gave me permission to distribute PDF versions of the book. And quite recently, I've lost track of the exact time, but thanks to the New Press, in record fast time, between the idea of the republication and the actual republication, the idea came jointly from my colleague Nico Perino, Executive Vice President of FIRE, and myself, in a webinar for FIRE, Foundation for Individual Rights and Expression. Nico and I both enthusiastically recommended the book, and one of the listeners went online and he said, but you could only buy copies of it for $400. So no freedom for that kind of free speech. And there were so many people who were involved in the republication. I just saw Jack, warden of this fine university, and his mother, Minky Warden. Obviously, my fire colleagues, I've already mentioned Nico Perino, Greg Lukianoff, who will be speaking. Narrative Brownlee was the project manager at the New Press, Diane Wachtel. It's the Chicago Forum. And by the way, it's so wonderful of you to host this forum on your second anniversary. Congratulations, just this week. Tom Ginsberg, Tony Benoot, and Tala Montjoy have been so wonderful. So in the honor of Chicago, I am wearing your maroon color. Thank you for having a very pretty color. Now, Aryeh, and please forgive me, I'm sure there are other people I haven't thanked, but this is a project to which so many people contributed, above all, Aryeh Neier, and I'm so honored to be sharing the platform with you, Aryeh. In your new chapter 10 for this book, you say that the republication is a cause for celebration. So maybe we can start there. Can you explain the significance of the case in the book and why you think at this particular time it is to be celebrated?
Well, first, I haven't previously been put in the same category as John Stuart Mill and Louis Brandeis, so thank you for that, and thank you for being the driving force in getting the book republished. I think you and the New Press in particular deserve immense thanks from me for seeing to it that the book was republished. I thought the Skokie case was important when it took place, not because it set a significant legal precedent. It did not. It was significant, I think, because it stimulated a conversation that involved a great many people in the United States. At that time, people engaged in arguments about whether, as despicable a group as the Nazis, should be allowed to conduct a march, and particularly to conduct a march in a village or town. I think it's more appropriate to call Skokie a town, where there were a substantial number of Holocaust survivors. I think the Nazis stumbled into Skokie. I don't think they knew that it was a place where there were a lot of Holocaust survivors. What happened was they were excluded from demonstrating in Marquette Park in Chicago, where they were represented by the ACLU, but there was a federal district court order excluding them from Marquette Park, and they wrote letters to a number of towns around Chicago saying, we're going to come and demonstrate in your town. And most of the towns ignored those letters. Skokie did not ignore the letter and in effect said, don't you dare come here. And Skokie adopted a number of ordinances to exclude the Nazis from marching in Skokie. It aroused a debate, and my impression was that many millions of Americans engaged in that debate. They had arguments over the dinner table. They had arguments in synagogues and churches and parent-teachers associations and in all kinds of places. And I had the impression that over time, the free speech side of the argument got stronger. I had that impression because I did a lot of speaking in churches and synagogues and colleges, And in the early part of the 15-month period that the case was underway, I would say that most of the audiences to which I spoke were largely against me. And then over a period of time, it seemed that the dynamic shifted, and that towards the end, audiences might be more evenly divided, that the free speech argument had gotten stronger. And I think it got stronger because people participated in those debates, and they persuaded themselves and persuaded each other of the free speech side of the argument. I think we're now, once again, in a period where free speech issues have come to the fore in the United States. That a lot of the actions of the Trump administration domestically have raised free speech issues. His attacks on the universities, his attacks on law firms, his efforts with respect to broadcast media. Now he's targeting foundations like the Open Society Foundations and the Ford Foundation. And once again, free speech is at the top of the agenda in the United States. And I hope that there is some kind of repetition of what took place nearly a half century ago with respect to Skokie. That once again, by taking part in arguments about Trump's attacks on freedom of speech, that the freedom of speech side of the argument grows in strength, that people persuade themselves and persuade each other that they need to defend freedom of speech.
Absolutely. So the timing could not be more auspicious for this republication. You know, a couple of comments. When I was ACLU president for many, many years, people would constantly, I could not speak anywhere without people bringing up the Skokie case. And you and I talked about this, Aryeh, bragging to me, I used to support the ACLU, but, and I said, I can guess what's coming after the but. I resigned over Skokie. And you said to me, Aryeh, if everybody who claimed to have resigned over that case had actually been a member, we would have been millions. So I think people have it, but I think they truly, you know, it was so paradigmatic of these fundamental ongoing debates. The question that I'm still asked to this day, and it has been raised with renewed force in light of more recent cases that the ACLU has handled, including defending freedom for Unite the Right protesters in Charlottesville in 2017. Yeah, it's one thing for the ACLU to defend the principle of freedom for the thought that we hate, to quote Oliver Wendell Holmes, but why should it be the ACLU in particular, with limited resources and a multi-issue organization to handle this case? And let me throw in another factor, alluding to my wonderful friends with FIRE, which also played a big role in the republication of this book. We now have organizations such as FIRE that did not exist then, that are full-time free speech organizations. So is it important for the ACLU to continue to handle these kinds of cases?
I think it's immensely important for the ACLU to handle these kinds of cases. First, there isn't any organization in the United States that has the comparable network that the ACLU has on a nationwide basis. There are ACLU state affiliates in every state. There are local chapters of the ACLU in many of the cities in the state. These are themselves substantial institutions. The ACLU affiliates have staff, they have legal staff. Many of the chapters have their own legal staff. They have volunteer attorneys they can count upon. Trump can attack freedom of speech, but no institution in the United States has the capacity to respond the way that the ACLU has the capacity. And these are, in general, not cases that require significant resources on the part of the ACLU. These are not cases which require very substantial evidentiary records of the sort of a, let's say, prison conditions case or a racial discrimination case. These are cases that can be handled by a staff lawyer or a volunteer attorney fairly readily. And in effect, they can make it clear that there isn't any place in the United States where free speech is off limits. And I think making that clear is immensely significant. If the Illinois ACLU represented the little group of Nazis that wanted to demonstrate in Skokie, they could make clear that Skokie would not be off limits for freedom of speech. But if there was a Klan group or a Nazi group or something of that sort that wanted to demonstrate in Indiana or Missouri or Minnesota, those places also should not be off limits for freedom of speech. Freedom of speech should prevail every place in the United States. And the ACLU had the capacity to do that and to make that clear, and in the process to engage citizens all over the United States in thinking about freedom of speech, and in that way being able to rally to address other matters of freedom of speech, such as those matters which have arisen today.
I'm going to ask you another question about the ACLU, and I want to emphasize the reason I'm raising the ACLU is, you know, people who fork over their membership dollars to become card-carrying members are really true believers in free speech, and yet even about 15% of those resigned because of the Skokie case. So I think the dissension, even within the ACLU, on a fundamental First Amendment principle that easily won in the courts of law, less easily ultimately has won, as Aryeh explained, in the court of public opinion. There continues to be strong dissent, including among a couple of the ACLU's semi-autonomous affiliates, about whether we should spend any of our resources, even if it's relatively few, defending freedom for those who oppose civil liberties or at least are not advocating civil liberties. So as you well know, Aryeh, there was a lot of dissent among a lot of staff members too about the ACLU's successful, in the courts, defense of the First Amendment rights of Unite the Right in Charlottesville in 2017, and more recently in NRA versus Vullo, which we won unanimously in the Supreme Court, but it's now overtaken, and we represented the National Rifle Association, the NRA, in asserting First Amendment rights that are now very important in all the litigation against the Trump administration. But I think the Vullo case has now tied with Skokie. When I speak to audiences, is why is the ACLU representing the NRA? So what do you think about these more recent
First,
cases?
with respect to the NRA versus Vullo case, for those of you who are not familiar with the case, it was a case arising because the Director of Financial Services for the state of New York had indicated to banks and insurance companies that they should refrain from dealing with the National Rifle Association because the National Rifle Association was carrying on antisocial activities. And the state had been upheld in the state courts and in the Second Circuit Court of Appeals. And the ACLU, David Cole as legal director, represented the National Rifle Association and took the case to the US Supreme Court and won a unanimous decision with an opinion written by Justice Sonia Sotomayor, making clear that this was a significant violation of the First Amendment. Now Trump is engaged in attacks on non-governmental organizations. The organization with which I was associated for so many years and with which I'm still associated with, the Open Society Foundations, has been specifically cited by Trump as one of the organizations which he wants to attack. I think there is probably no legal precedent that is more helpful to the ACLU, to the Open Society Foundations, than that Supreme Court decision in National Rifle Association versus Vullo. I think the fact that it was the National Rifle Association that happened to be an issue probably helped account for the fact that it was a unanimous decision. The fact that Clarence Thomas and Samuel Alito joined in that decision probably had something to do with the fact that it was the National Rifle Association. So that was an indication of the way that defending freedom of speech for the organization that might be considered the enemy could be of immense value to organizations with which I'm personally identified and with which many of you may be personally identified.
The ACLU definitely paid a price for standing up for free speech principles. It was, as I already mentioned, we lost a significant number of members and associated revenue. It was before my active involvement, but I know it was a time of financial stress. Recently, and I know you've said that we overcame that relatively quickly.
Let me just say, we overcame it rather quickly. You're going to hear later this afternoon from David Goldberger, who was the attorney for the Illinois ACLU who represented the group of Nazis. We sent out a letter in David's name at the point where the case had been won for the free speech side. And we solicited extra contributions to make up for the financial losses. Mm-hmm. And that was the most successful fundraising letter that we had sent out up to that point. And by itself, that helped to overcome a large part of the losses that we had suffered up to that moment. So I don't think the ACLU harmed itself. Mm-hmm. If anything, it strengthened itself by its engagement in the Skokie case. It didn't engage in the Skokie case to strengthen itself. That was a byproduct, yeah. But it was a very right. Nice byproduct.
But at the time, I give enormous credit to you and Norman Dorson, my predecessor as president, to David Goldberger. You could not foresee that the organization would recover relatively quickly, quite the contrary, and yet you still were determined to take the risk. And I stress that because now we see organizations that are, dare I say, more powerful powerful, wealthier than the ACLU by far, that are not taking what seems to be not very much of a risk in settling with the Trump administration on First Amendment claims that they could clearly win in a court of law. We're talking about major law firms, major universities, major social and general broadcast media platforms. What lesson should they learn from the Skokie case?
Well, I think the most important lesson to learn is that when there are these attacks on fundamental rights, one has to resist them. And the most depressing thing about the current situation is the way that large, wealthy institutions have succumbed to the pressure of the Trump administration. The fact that elite universities, for the most part, have settled with the Trump administration. And to me, the most depressing thing has been the way major law firms collapsed or capitulated in the face of the pressure. Those law firms certainly knew that they could prevail in court. Trump targeted law firms that had antagonized him on a personal basis. The basis, for instance, for his attack on the first of those law firms, which was targeted, the Paul Weiss firm, was that one of the lawyers in that firm had taken a leave of absence in 2021 to work with the Manhattan District Attorney's Office in an investigation of Trump's business firm. And the executive order provided not only that the federal government would not deal with those law firms and that lawyers from those law firms would be denied security assistance, but that personnel of those firms would not be allowed to enter federal buildings, as if the federal buildings were Trump's personal property and he could exclude lawyers from firms that had antagonized him personally.
He should pay real estate taxes on that property.
It was patently absurd, and the firms could easily have prevailed. But in effect, they thought paying him off would be better. And CBS and ABC both settled lawsuits that were clear losers from Trump's standpoint by paying him off. They each agreed to the same amount, $16 million, $15 million in the case of CBS, and an extra $1 million for legal costs, and $16 million in the case of ABC. And in the case of CBS, the executive producer of 60 Minutes resigned. The woman who headed CBS News resigned. Those were firms that were concerned with the ways in which federal agencies would react with respect to matters that involved their business interests. They had large amounts of money at stake, and so from their standpoint, it was better to settle with Trump than to defy him. There have been many periods in American history when free speech issues were under attack. The First World War period, when opposing U.S. entry into the war or opposing the draft became the basis for prosecutions after the First World War, during the period of the Palmer raids, at the time of the Red Scare after World War II, during the Vietnam War period. There have been those periods, but the people under attack at those points were anti-war activists, campaigners for birth control, radicals of various sorts. Many of Trump's targets have been established institutions which have large amounts of money at stake. And Trump has read those institutions and understood that they were vulnerable because of their financial interests. And he's been able to get away with many of his attacks on freedom of speech because he has accurately discerned that vulnerability. And it's that vulnerability that has proved the most significant basis for attacking freedom of speech today.
And that leads to a question that you and I have already talked about, which is what advice you have for those of us who are humbly trying to follow in your footsteps, given the changed nature of the challenges that we have now, where on the one hand, the First Amendment free speech law is much more protective than it was during these earlier periods. On the other hand, we see a crumbling of the civil society organizations, including the press and universities and law firms, that, not to mention the checks and balances that should be provided by Congress that is supine. How do we navigate this changed landscape?
I think one navigates it by resistance and also by criticizing those who succumb to the pressure. One of the episodes that turned out well, I think, was the whole Jimmy Kimmel episode. And I had never expected to look to Ted Cruz to defend the First Amendment. But Ted Cruz saying that the way in which the chair of the Federal Communications Commission acted with respect to ABC television was characteristic of the way a mafioso would react. And I think that probably had a significant impact in getting the Disney Corporation, which owns ABC television, to change course on the Jimmy Kimmel affair and to put him back in television. So resistance and criticism work.
Here on a college campus, I have to bring up what has been one of the major free speech issues in the past couple of years, and that is campus protests and the reactions, in some cases underreactions, in some cases overreactions of university officials. And the Trump administration and other government officials have invoked concerns about anti-Semitic discrimination as a rationale for restricting protest, which obviously is analogous to the Skokie situation. Yes. So what lessons can we draw from that in light of the current debates about Title VI?
You know, again, I think it's important for universities to stand up for freedom of expression. Clearly, there are limits to the kinds of demonstrations that can take place on college campuses. There are appropriate concerns about, time, place, and manner with respect to demonstrations. One doesn't want demonstrations which disrupt appropriate university activities. But the content of what people have to say, the viewpoints that may be expressed, should not be part of the restriction. The restriction should be based on whether there is any disruption that takes place, rather than on the viewpoints that are expressed.
I think we have time for only one other point before we turn it over to the audience. And I would like to, before I do that, Aryeh, read something from the afterword of my book, because it relates very much to the University of Chicago and this wonderful forum. I'm quoting a then student here named Olivia Eve Gross, who graduated in 2024, and she was one of the student advisors to this wonderful forum. She sent me an email reminding me, and she's very typical of the kind of compliments I get for the importance of this book. So her email reminded me, the first time we ever met, she was an undergraduate then, you told me to read Defending My Enemy. It changed my life, and I go back to it often. She added that, going back to our last subject, after October 7th, with everything going on related to the encampment at the University of Chicago, I kept my copy of Defending My Enemy on my desk. It quite literally got me through that year when I was constantly grappling with my proud advocacy for free speech and the anti-Semitic speech I was hearing every day. Neier is a hero of mine. So thank you so much.
Thank you. Thank you.
Thank you. So my role, I'm Tom Ginsberg, I'm the faculty director of the forum. My role is to ask the questions for these two folks. And so if you have additional questions, you can email them to the Chicago Forum at uchicago.edu. And a first question that came in is, Aryeh, do you think that your defense of this speech opened the door to more harmful speech? We live in a time when there's been quite a bit of degradation of speech generally. Did defending that speech make things worse?
I'm sorry.
Yeah, I'll repeat it. So do you think that your defending freedom of speech in Skokie created a climate that has led to more harmful speech, a degradation of speech?
I don't think so. I'm not sure that the period in the wake of the Skokie case manifested that kind of harm. I think Skokie had an effect for, a decade or two on thinking about speech. I don't think it lasted longer than that. But I don't recall during the 1980s and the 1990s that there was any harmful consequence of speech during that period. Of course, there are always, some harms that may be associated with speech if there is hate speech of various sorts. But it doesn't seem to me that that was a period when there was a larger amount of hate speech than was ordinarily the case. Internationally, that was a period of great progress, and there were parts of the world, the former Yugoslavia and Rwanda, where hate speech played a particularly harmful effect. But I think the reason hate speech played such a harmful effect in those contexts is that the only speech that was available in broadcasting in those contexts was the hateful speech of RTLM in Rwanda and radio television Serbia in the Yugoslav context. If there had been free speech more generally, and other points of view could have been expressed in broadcasting, I think it is possible that we might have avoided some of the terrible harms that took place in that period. So I'm always an advocate of more speech as the best remedy for hateful speech. I think opposing points of view and disseminating opposing points of view is by far the most desirable response to hate speech.
Yes, I'd like to follow up on that. So, of course, much of your work has been about promoting open societies in many other parts of the world. And many of the other democracies around the world make a different judgment. They do have hate speech laws, they do have restrictions, and they still seem to be democratic states. So I guess, I guess my question is your answer a universal one, or is it viable for democracies to make a different choice? And how does that work out when they do decide to criminalize hate speech?
You know, I'm not aware of any country that could be considered a democracy that does not favor freedom of speech and provide significant opportunities for freedom of speech. I think freedom of speech is probably the most essential defining characteristic of a democracy. I think that if one is looking at repressive regimes where there is a great deal of ethnic violence, those tend to be the countries where freedom of speech is repressed.
Mm-hmm. This is a question about the ACLU, so it's sensitive, which is...
we have thick skin.
Yeah, I know you, of course. So the tenor of it is that the ACLU has in recent years taken up a number of more progressive causes. The leadership in this area seems to have passed to the FIRE and other organizations, which have made it a very central and sort of bipartisan issue. Is that an accurate representation? And what generally has happened to the left's representation, relationship with free speech more broadly?
This is a question I constantly get, I'm sure you do too. Has the ACLU abandoned its principled defense even for non-progressive speech, or has it become more focused on defending progressive leftist causes and ceded the ground of neutral defense to an organization like FIRE?
A lot of the public attention to ACLU litigation today involves issues such as immigrants' rights. So the ACLU is very much in the forefront of resisting Trump's policies with respect to immigrants' rights. And there are, quite a lot of other issues with which the ACLU is concerned today. But I think it is also significantly engaged in First Amendment matters. I think the ACLU, to a certain extent, has suffered from its own success. And I think, let me explain it this way. Trump has been very good for the ACLU institutionally. That is, in the first Trump term, the ACLU had a huge influx of members and contributors. And the same thing is true right now. So the ACLU nationally today has about 1,200,000 members. It's an immense organization. One of the consequences of that is that it has increased its staff a great deal as a consequence of that. And many of the people who have joined the staff of the ACLU are young attorneys who haven't been through the free speech battles of the earlier period. And so within the ACLU itself, it has been necessary for the institution to debate the issues with which it was traditionally concerned, and to try to bring the new employees of the ACLU along. The attorney who litigated the National Rifle Association versus Willow case, David Cole, who had served as the ACLU legal director for several years, has returned to his teaching position at Georgetown Law School. But David in particular seemed to me to work very hard to sort of bring the new lawyers on the staff along in terms of the free speech principles of the organization. And the organization's executive director, Anthony Romero, has very much backed that effort on David's part. There's an internal education process that is required at an institution as large as the ACLU. One of the things you have to remember about an organization like that is that it's not an organization where there is a kind of centralized command and you can, with a fiat from on high, determine the way everybody acts. The organization is a potent force in American public life because of the high degree of autonomy owned by the state affiliates of the ACLU. In my day at the ACLU, there were affiliates that dissented from the position taken by the national ACLU, and I understand that two state affiliates, I think New York and New Mexico, dissented from the ACLU's engagement in the National Rifle Association versus Willow case. So 48 state affiliates and Washington and the National Capital Area, it's actually more than 48 affiliates, because California has 3 affiliates, Missouri has 2 affiliates, there's the National Capital Area affiliate. But each of those institutions is a significant institution unto itself, and the fact that it's a significant institution unto itself makes it a potent force within its territory. But one doesn't have the capacity at the center to lay down the law and everybody follows the law.
Thank you. A lot of our discourse, this questioner poses, surrounds legal and institutional governmental suppression of speech. We're in an era now where social limitations, private company limitations on speech are equally profound. And are you concerned about that? What steps must we do to actually ensure an environment of open discourse?
That's a difficult question. The First Amendment is a limitation on what the government can do. Private institutions are not governed by the First Amendment, but in the nature of a complex society, private institutions exercise a significant amount of power. And in the United States in particular, private institutions exercise power that in some other countries would be exercised by the state. And so I think one has to try to create an atmosphere in which a significant number of private institutions will adhere to what would be the principles that are actually binding upon the federal government. Private universities, for example, are not governed by the First Amendment. But for private universities, it should be apparent that encouraging the free exchange of ideas is immensely important to the mission of a university. And one should try to see that major private universities adhere to the same standards that are required of public universities by the First Amendment. There may be, small religious institutions that have entirely separate concerns, and for them to adhere to their own religious practices is itself something guaranteed by the First Amendment. So one has to examine these situations and see where it's appropriate to try to foster compliance with public standards as to the protection of rights.
If I may say, in that vein, we have to salute the University of Chicago because it is a private institution, and yet these Chicago principles, which I like to think of as the Stone principles, since the principal author was my dear friend and colleague, Professor Jeff Stone, that is the gold standard for free speech and academic freedom for public as well as private.
Jeffrey Stone has made an immense contribution, but the University of Chicago, well before Jeffrey Stone, through figures like Robert Hutchins and Harry Calvin, was probably the leading university advocate of the principles of freedom of expression.
And I hope everybody has the Chicago Canon produced by this wonderful forum, which is a compendium of the wonderful history going back literally to the very founding of the university.
I'm going to take that endorsement with gratitude, and I'd like you to join me before we bring the next panel on to thank Aryeh Neier and Nadine Strossen.